I'm 6 videos behind, so as a punishment, I'm going to go ahead and do the next 6 videos as the Mad Hatter. The Mad Hatter here with part 18 of the My Docket series on Corazon real estate. You know, there isn't a whole lot I can mention on the mindset portion because for the most part, we're going into the Supreme Court appeal, and all of the thoughts that I have in drafting the brief are the same as the thoughts that I have from the last 2 or 3 videos when the order granting motion to dismiss was entered, and also when the opposition, or well, I guess you could say my opposition and reply, were considered on the channel. So I think at this point, all we're going to have to do is go straight into what I have filed. So before I actually go into the opening brief that I filed, there are, it looks like 4 ancillary documents that I wanted to cover in order, and I think it's going to be more confusing if I try to move them around. So these are the filings in the order that I received them from the Supreme Court. The first is a notice of potential dismissal for failure to pay the filing fee. If you can recall, going through the series, I actually got an order granting the fee waiver, so the Supreme Court is just not aware of it yet. Once the Supreme Court gets that order granting the forma pauperis status, then they're going to go ahead and proceed with the appeal. But I still wanted to show you this because it was actually filed in the case. Certificate that no transcript is being requested. I think I've talked about this before. If you want to learn more about what this is, please watch my video on the topic, the transcript request form. And at this point, or actually what I should say is in this specific appeal, there was no hearing. And since there was no hearing, there is no transcript. All that is going to be considered by the Supreme Court is the paperwork itself, because that's all the judge considered. Here we have the motion for extension of time on filing fee. I filed this motion because I wasn't sure when the lower court was going to rule on my motion or application to proceed in forma pauperis. And this was just me doing my due diligence, letting the Supreme Court know that, hey, I know the filing fee is due within a certain amount of time, but the lower court still hasn't made a decision on my fee waiver. So, I mean, I could go through this. I'm hesitant to do that because let's just take a quick look. Factual background. December 5th, we've got an order granting motion to dismiss from the lower court. December 10th, I filed a notice of appeal. December 17th, the Supreme Court entered an order directing I pay the filing fee within 10 days. And then we have the law, which is Rule 24 sub A1, which mentions that you cannot ask for a fee waiver in the Supreme Court until you ask for one in the district court. To date, the Chief Judge of the 2nd Judicial District Court has not rendered a decision. The District Court Clerk has advised the plaintiff that it can take up to 60 days to render a decision, and the time that it takes for the District Court to make its decision would frustrate the purpose of the appeal. Pretty logical stuff. And then I go ahead and I mention in conclusion that I'm requesting the Supreme Court vacate its order requiring the filing fee be paid within 10 days, and instead order that the filing fee be paid within 10 days of a District Court order denying forma pauperis status. Supreme Court order. Well, I'm also asking the Supreme Court of Nevada to order me to file an application to proceed in forma pauperis in the Nevada Supreme Court immediately. Oh, I see what I'm saying. It's not that I'm also asking for this. It's that I'm asking for this in the alternative. So basically, I'm telling them, you know, either vacate this order or let me just file the request up here right now. And then we've got the Rule 5 Certificate of Service indicating this document was mailed to Charles Shinichi. Motion requesting determination on the respondent's representation. Okay, I remember this because this is an issue now in the Supreme Court. Whether or not a non-attorney can represent a business entity. The Supreme Court has to make the decision just like the lower court has to make the decision. And so I'm not going to go through this because it's probably going to be based on all of the same points of law and fact that are mentioned in my motion to require Corazon real estate to obtain counsel. The only difference here is it's just a different court. It's the Supreme Court instead of the District Court. But it's going to be based on the same facts and the same law. It's just a copy-paste. Certificate of service indicating this motion was mailed to Charles Shinichi. Now we've got the opening brief. So this is the main document in this video. Standard introductory paragraph indicating that this is filed in proper person, which means I do not have an attorney. And I think I've mentioned this before, guys, that the opening brief is not supposed to look this way. I have seen Supreme Court opening briefs. They look very different. The front page is like, this looks like almost like a motion, well, exactly like a motion that's filed in the lower court. And in the Supreme Court, at least in Nevada, the format for what page 1 of an opening brief is supposed to look like is, if I remember correctly, completely different, with the title, with both attorneys' names right beneath the title. I think I've talked about this in the video filing an appeal, so I may have more details in that video. Rule 26 sub 1 or point 1, sorry, disclosure, which is just disclosing that there is no parent corporation. This is something that I assume the Supreme Court keeps track of when it comes to giant corporations, in their courts, because some corporations are owned by other corporations, which are owned by even more corporations. There's like nested ownership and all that. Table of contents, which is just breaking down all of the sections by page. Table of authorities, which is breaking down where all of the rules and cases are mentioned in the opening brief. Those are required, by the way, and that's because the rules of appellate procedure say so. Jurisdictional statement, also a section that is required because the rules of appellate procedure say so. I don't think that this one is as complicated as the last one that we went over, and that's in the high conflict child custody series. But in any event, I'll very briefly go over it. Order granting motion to dismiss. It is not interlocutory. In other words, it is a dispositive motion. It closes the case completely, which under Rule 3A sub B1 renders that an appealable order. And I also cite Lee versus GNLV Corp, which probably quotes Rule 3A sub B1. I'm mentioning that I am aggrieved by the order as it disposes of my claims with prejudice. And then we've got 3A sub A, and I also cite a case that discusses or defines what an aggrieved party is, which is one that is injuriously affected by the court's adjudication. Original jurisdiction is established in the Second Judicial District Court. The dispositive order was entered November 27th, and the notice of appeal was filed timely on December 10th, 2012. Application to proceed in form of paupers has been filed in the lower court and is pending. Then we've got the statement of issues, also required because the rules of appellate procedure say so. Just breaks down the issues. Number 1, did the district court err in applying the wrong standard of review for a motion to dismiss, which I believe it did. Number 2, whether the district court abused its discretion by refusing to deny my motion to dismiss. By refusing to deny the respondent's motion to dismiss for failure to comply with Rule 13 sub 2. Number 3, whether the district court erred in dismissing the complaint for lack of evidence before discovery has been conducted, which I don't even think, maybe in summary judgment analysis that would be relevant, but in this case, I don't believe that analysis even came about. It was just a dismissal for failure to state a claim analysis. And then number 4, whether the district court committed legal error by allowing a non-attorney to represent the domestic corporation, which is this is the issue that the Supreme Court laser beams in on. Statement of the case. Parties once shared a landlord-tenant relationship throughout the relationship. And I've talked about this before throughout the lower court case, so I'm just going to briefly state that there was a threat to evict for not making certain repairs. Their argument is that I had to make the repairs. My argument is that they had to make the repairs as a landlord, and that they, by using their ability to evict, committed oppression, which triggers an award of punitive damages proven, which is what puts this case in the district court. Same stuff that I've been talking about throughout the series. Factual background, we got the dwelling unit. All of this, I don't even think this is supposed to be in this brief. I really don't. And this has all been, this is copy paste from the motion practice in the lower court. So I'm not going to go over this again. This is the exact same stuff, just copy pasted into the Supreme Court opening brief. Procedural background, all I can assume here is that this is when the documents were filed. Not really needed. They're going to get something called the record on appeal from the lower court. That's going to contain all of this information. So it's really superfluous. The summary of the argument. So I'm arguing that a claim for punitive damages, or the opponent, which is the landlord, or I keep saying that, the Corazon Real Estate Corporation, is claiming that the punitive damages are ashamed to establish jurisdiction in the district courts and that it should have filed it in the justice courts. They are saying that I'm bringing the issues of malice and punitive damages, and here's oppression. Okay, so oppression, malice, and punitive damages to to basically put this case in the district court, which is what they don't want. They want it to be litigated as a small claims action. And I'm arguing that this is actually a valid concern, or a valid claim that I'm making. Summary of the underlying argument. So they've maintained that I should be bound by a contract assigning maintenance of an air conditioner, and I am arguing that the contract is adhesive, that the provisions requiring me to maintain the air conditioner are ambiguous, and that they should be construed against the landlord, and that it's contrary to public policy, which I think is the main argument here, because there's a bunch of statutes in Nevada that say specifically what a landlord is supposed to pay for. And in those statutes themselves, there's another statute that specifically says that if you have a tenant sign something in their lease or whatever contract that is that they're signing, that if it's contrary to the law, then that particular provision in the lease/agreement is void as contrary to public policy. If you think about it, that makes sense, because otherwise they could just pass all sorts of laws to protect people, and then landlords can just get people to sign away all of their rights. And it's an issue because a lot of people don't read what they sign. This is probably going to trigger a bunch of arguments back and forth. If you want to know more about why this is such a complicated issue with a lot of debate behind it, please watch my video on the topic. I think it's under procedural unconscionability, or maybe it's under contract unconscionability, or maybe it's under substantive unconscionability. Most likely the video is called contract unconscionability, most likely. If not, check for the other titles. And then there's another video that's relevant that's called adhesion contracts. And those two videos explain all of the debate behind what I just said, because there really is a lot of confusion behind whether or not they can pass a law that somebody can then turn around and waive. It's a little tricky, it's a little complicated. Appellant argues that punitive damages are appropriate in order to punish a wrongdoer for an intentional tort so as to discourage such further conduct, which is true. If you want to know more about why I think that, like, it's just my idea, there's a bunch of research on this. If you want to know more about all of the research and the discussion behind it, please watch my video on the topic punitive damages. That video explains the details. Argument and legal analysis. So we got motion to dismiss, alleging that I saw punitive damages in order to get my case filed in district court rather than small claims court. Respondent concluded that the claims should be dismissed and remanded to the small claims court. I filed an opposition to that motion. I cited a case called Aftercare v. Clark County, which is an interesting case because this issue has been brought up before. And the Supreme Court of Nevada stated that it's actually constitutional. It's a constitutional right for a plaintiff to file the case where they want to file it. They can lose the case depending on where they file it, but they can file it there. And then it mentions that you can't really force someone into a small claims action just because they're under the threshold. It's really up to the plaintiff whether they file a small claims action or a civil action. And this is stuff that I've talked about a little bit in this series. The Supreme Court's not going to go into any of this. They're just going to hone in on the fact that a non-attorney was permitted to represent a business entity. So I'm not going to spend too much time on it, but I do want to at least very quickly touch on it. I filed a reply to opposition reiterating... Charles Chinichi filed a reply to opposition reiterating the same stuff, basically that it should just be filed as a small claims action. So first, I argue that the district court erred in dismissing the case with prejudice for lack of evidence. I could go into all of these cases, and I guess very briefly I will, but really, I talk about this a lot more in the video Early Case Termination, and then there's another video called Motion to Dismiss for Failure to State a Claim. Those two videos really go into the nitty-gritty on what exactly the landlord did that Corazon Real Estate did that they shouldn't have done. But just very briefly, I mentioned that the district court granted dismissal on grounds that there wasn't any evidence provided. And I'm firing back that pursuant to Vacation Village Incorporated versus Hitachi American, that the standard for review under dismissal under Rule 12 sub B5 is rigorous, in that the court has to construe the pleading liberally and draw every fair intendment in my favor. And that's what the judge didn't do. I don't have to prove anything. The judge is just supposed to assume that what I said is true. And that's the whole way that's how you start a Rule 12 sub B5 analysis. He's not supposed to expect evidence that early in the case. It's completely ridiculous. And then we've got another mention of the standard of review on the motion to dismiss, or I guess that's appellate terminology, the standard of review for this court, which is to determine whether or not the challenged pleading sets forth allegations sufficient to make out the elements of a right to relief. There are certain elements that I have to show. If I have alleged what I needed to assert those elements, then it should survive the Rule 12 sub B5 motion. Later on, evidence is going to get looked at. Later on, there's mid-case terminations, another video that I have, which talks about summary judgment and other ways to throw out a case. And then finally, of course, you have trial. But this is way too early for the judge to have required evidence. And then I mentioned another case, this is what I was talking about earlier. This is Vacation Village Incorporated versus Hitachi, which states in bold, all factual allegations of the complaint must be accepted as true. Okay, so the district court exceeded its authority under the motion to dismiss test in demanding evidence to substantiate claims. Obvious stuff. I really don't think that this is something the judge didn't know. I really do think that the judge did this on purpose because he just wanted to get rid of the case. Sometimes they'll play dumb. It's way too difficult to believe that the judge did not know this. It's just too basic. It's elementary. District court erred in refusing to deny motion to dismiss per DCR 13 sub 2. This is another basis that I'm using. 13 sub 2 required Charles Tracie to cite points and authorities, and he did not do that. So his failure to do that is a basis to dismiss or to deny his motion to dismiss. And then district court committed plain error in requiring evidence before discovery. And this is me just kind of assuming maybe they're going to wander into the summary judgment analysis, but they really don't. Later on in the case, this comes up. But, I mean, if you want to learn more about why this matters, watch my video on the topic mid-case termination, and then watch my other video on the topic summary judgment. And I guess you're going to end up wandering into the videos on discovery. But really, this is kind of a stretch. I mean, the court just did not even go this far. There is a lot of case law on it, as you can see. A district court erred in allowing a corporation to appear in proper person. This is what the Supreme Court's going to hone in on. This right here is what they're going to reverse on. So it's not factually in dispute that Charles Tracie is a non-attorney representing a domestic corporation. There are multiple cases in Nevada that do not allow this. There's also a local rule, which is WDCR 23.5. Corporation may not appear in proper person. Discipline of Schaefer, consistently held that a legal entity such as a corporation cannot appear except through counsel. Sunday versus Contel of California, and then Selman v. Newell, both cases say the same thing. The district court erred in allowing Charles Tracie to represent his corporation. This is exactly what is going to get Judge Freeman dinged on appeal. Conclusion: district court should be instructed to reanalyze the motion to dismiss, assume each allegation true, etc., etc. None of this happens. The Supreme Court just scolds the judge for allowing a non-attorney to represent a corporation, and he orders the judge, or the Supreme Court orders the judge to strike everything that Charles Tracie has filed as a fugitive pleading. Declaration of fugitive pleading / paper. Pleadings are very specific in Nevada. Not everything filed is a pleading. There's a definition for what a pleading is in the state. Anyway, a declaration indicating that the contents of this brief are true and correct under penalty of perjury. Certificate of service indicating this document was mailed to Corazon Real Estate. Then here we have the order denying motion. December 19th, I filed a proper person motion for an extension of time to obtain an order from the district court to allow me to proceed in form of papyrus. However, on January 31st, the district court filed with the court a copy of their order granting my motion to proceed in form of papyrus. Accordingly, my motion is denied as moot. And what they mean by moot is it's not an issue anymore. I no longer even have to pay a fee. I can just file this appeal for free. So if you want to learn more about that, watch my video on the topic mootness doctrine. I think it might just be called mootness. The video is either called mootness or mootness doctrine, one or the other. Next, we have the order placing the appeal in the pilot program for civil proper person appeals. So this is interesting. In hindsight, makes me think that civil proper person appeals were a new thing in the Supreme Court of Nevada. That's what this makes me think. They're talking about a pilot program. Maybe it's just a pilot program that's new. Maybe. In any event, they don't do this anymore. As far as I know, you just kind of, just move along like a normal appellant. I don't know what this is about, but let's take a quick look. Proper person appeal. Dismissing my complaint. After filing fee issues are resolved, the appeal is placed in the court's pilot program for civil appellants proceeding in proper person, and the clerk mails to the appellant a civil proper person appeal statement. Okay, so a generic form for litigants who don't have attorneys. In this case, before the filing fee issue was resolved, the appellant filed an opening brief. Apparently, you needed permission to do this before? You don't need permission now. So apparently before, there was a rule of appellate procedure called 46 sub B that said you can't file an opening brief unless you get permission from the court. That's what I'm assuming, and I just can't remember this. Okay. Anyways, this is no longer required. You can just file an opening brief now. You don't need to get permission anymore. If you didn't have an attorney back then, it seems like you needed to get permission. And they, let's see here. Nevertheless, they direct the clerk of the court to place the appeal in the pilot program, to mail me the instructions, to contemplate review of the complete district court record. They strike an appendix. Oh, interesting. So that means I filed an appendix. And this is what I've talked about. If you don't have an attorney, you don't have to do this. So they're striking my appendix because I don't need to do it. The reason why is if you do not have an attorney in Nevada and you file an appeal, what they do instead is they order the district court clerk to transmit the entire record to the Supreme Court. An appendix is just a portion of a record. So if they're going to get the entire record from the lower court anyway, then they don't need an appendix. Now, if you have an attorney, that doesn't happen. If you have an attorney, they will not transmit the entire record. The attorney does have to file an appendix. So just make sure that, we're clear on that. What else do we have here? Yeah. Okay, that looks like everything. Going into the aftermath, I filed, let's see here, 1, 2, 3, 4 documents. 4 documents. They were all free filings, so I incurred $0 in costs. Charles Tracie didn't file anything, so we incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. Corazon Real Estate will eventually be forced to get an attorney, at which point they will probably very, very quickly skim over all of these documents. I don't imagine they'll spend more than 15 minutes on it. And that, at the rate of $250 an hour, is going to come to $62.50 in attorney fees for Charles Tracie. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.